Hi everyone, welcome to our webinar about fair housing. My name is Christy Baglow. I'll be in the background running the slides, and I'm going to pass it over to Joe Cordova, who will be giving the presentation along with Veronica Robleto, both of Florida Legal Services. Welcome, Joe and Veronica.
Thank you, Christy. Hello, my name is Joseph Cordova, and I'll be co-presenting along with Veronica Robleto this evening. And tonight we're going to give our Fair Housing Basic Rights presentation. And we're delivering this to an audience and anticipating the farm worker community. But if you're watching this video via recording, hopefully you find something in this presentation that relates to you, and the contact information we post later on. We are always available for more questions, whether you're watching this live or not. And Veronica, would you like to introduce yourself?
Sure. Hello, everybody. I'm Veronica Robleto, and I'm a paralegal at Florida Legal Services, working on the Fair Housing Project as well.
All right, terrific. All right, so we'll go ahead and jump in. The very first slide we have ready for you. So have you ever heard, sorry, we don't rent to families with children, or this apartment isn't going to work with your disability, or sorry, you need a social security number to rent here, or this neighborhood probably isn't the right fit for you? If you've ever heard anything like that, or any similar stories to you, or any similar phrases or reasons for denial, there's a chance that this is based in discrimination. Next slide, please.
And sorry to interrupt, but did we want to do our poll as well about knowledge?
Yeah.
Housing?
Okay, yeah, for our audience, we have a poll for you. How would you measure your knowledge about your rights in respect to fair housing? If you don't mind answering that. 1 being not a lot, and 5 being I feel very confident about my knowledge, or anywhere in between. So, all right. All right, well, we can, looks like we're averaging 3.5. Perfect. Okay, so as I mentioned, if you've ever heard a phrase like that, this may be a violation of fair housing. All right, we can remove the poll and we can move to the next slide. And Veronica, let's go back and forth. Okay, yeah. So the Fair Housing Act, the Federal Fair Housing Act, prohibits discrimination in housing-related transactions because of race, color, religion, national origin, sex or gender, disability, or familial status, meaning your family has minor children under the age of 18. Next slide, please. And we'll go to the next one. Go ahead, Veronica.
Okay. What is a housing transaction? Is that where we're at?
Yes.
Okay. So when we say housing transaction, we are speaking of anything in regards to rent, sales, home mortgages or loans, appraisals, or homeowners insurance.
And Veronica, I'm going to let you do the next one so we catch back up on who's doing which slide.
Sure. All right. So who needs to follow the rules? And that's landlords or owners, homeowners, real estate agents, lenders, insurance companies, and homeowners associations.
All right.
And oh, I'm sorry.
Go ahead.
Are there any exceptions? So there are a few exceptions. Owner-occupied buildings with no more than 4 units are exempt, meaning if the owner lives in the building and there are less than 4 units, and also communities that qualify for housing for older persons are allowed to exclude families with children under the age of 18.
So I'm going to pause real quick before we do the next slide. There's a lot of questions around age discrimination in housing. Okay, if you deny housing to somebody based on their elderly age status, Technically, that might not be a fair housing violation, but it's still a civil rights violation. And so we get into the details of a discussion like that. There's still going to be some sort of violation of law, but it might not be specific to a fair housing violation under the Federal Fair Housing Act. The Federal Fair Housing Act identifies age-related discrimination to be a family-based discrimination. If you're trying to apply for housing and you have children under the age of 18, and it's denied because of that, that's where the age-based discrimination comes into play. But if you're a community for older persons, so like 50 and over, retirement communities, they are exempt from having to allow families with children under the age of 18. But we'll hopefully in the Q&A discussion, we'll kind of talk a little bit more about age-based discrimination versus family-based discrimination. All right, next slide, please. And Veronica, I think that's still you.
Yes, so we'll go 2 ahead to, protected class. So when we talk about protected class, what do we mean? This is race, disability, sex or gender, national origin, religion, and families with children. Next slide, please.
And one thing to talk about as we go to the next slide, and we'll talk about this later on, is that to be a member of a protected class doesn't mean specific races or specific genders or specific religions are protected. We're all protected no matter what race, religion, gender we are. It's that if that is ever used against you, it's protected. And we'll talk more about that a little bit later on. So when we talk about race, the denial of housing or housing services cannot be based on your race, color, or your perceived race. And this is going to be a running theme in this discussion. You may or may not be the race that someone thinks you are, but if they're using it against you, it still qualifies as race-based discrimination. So we live in a very diverse country, and we often consider race equivalent with color of skin. So if your color of skin is the reason someone is using or if someone is denying housing because of the color of your skin, but you actually don't identify as that race, it doesn't matter. They're still discriminating against the color of your skin. So you do not have to have minority status or belong to a certain race. And again, whatever race or color you are, it cannot be used against you in relation to housing.
Next slide. So similarly, religion, you cannot be denied housing based on your religion or faith, and this also includes perceived religion, correct?
Yes.
If you're being discriminated against, you don't have to identify with any particular religion, but if it's being based on your religion that you're being discriminated against, it would qualify as a fair housing violation. And if someone turns you away based on your religion, it's definitely a fair housing violation.
And just to add one more idea to this, let's say you have an example where maybe a Christian community says we only rent to Christians. I don't want to jump out right away and say you're exempt because you identify your community as a Christian community. But if it's, say, for example, like a Christian-based camp or something very specific to a church-related like congregation, there may be flexibility in exemption there. But if it's just a general public or even a federally financed government funding housing or just a traditional landlord-tenant relationship, if they say we only rent to Christians and you actually are Christian, but they're going to use it against you, that's still going to be discrimination. Again, you don't have to prove that you are the religion that they say you are. All that has to happen is that someone is trying to use religion as the reason to deny you housing. Okay, next slide.
This is you again, Jeff.
Okay, so when we talk about sex, gender, we'll kind of try to get a little more detailed here. So housing or housing services cannot be denied based on your gender. We're talking how you identify, if you are a female, if you're male, transgender. If there's ever a situation where a landlord says, based on who I think you are, regards to gender, I'm going to deny housing to you based on that, that qualifies as discrimination. One thing to also add to it is that underneath the topic of sex and gender is sexual harassment. The Fair Housing Act also prevents and protects you from any intimidation, threat, or harassment related to housing. And we'll have a little question later on when we go through some examples, but I want to make sure you understand that if a landlord is saying, I expect some sort of sexual relationship in exchange for the housing, that qualifies as a violation of the Fair Housing Act. And you don't necessarily have to go through the I'm a man, she's a woman, or whatever kind of the differences in genders are. What we're talking about when it comes to sexual harassment is that sexual relationship was made a condition of housing. So like I said, landlords cannot make sexual activities a condition, and any sexual harassment linked to housing. So we're talking about eviction, money, paying rent, maintenance and repairs of the housing. All of that is a cause for concern and is likely to be a violation anytime sexual harassment enters the conversation of that landlord-tenant relationship. Okay, so next slide.
Thank you. So national origin, where you, your family, or your ancestors are from cannot be used as a reason to deny housing or housing services. Sometimes landlords, lenders, or insurance companies might require proof of legal status or social security number in order to provide access to credit scores, income, or conduct credit checks. However, be aware that denying housing based on not having a social security number may just be an excuse to deny housing based on national origin. The language you speak or speaking English with an accent is also not a valid reason to deny. Now, for example, the social security issue, they may ask, and they're allowed to ask for a social security number to do, for example, to conduct a background check. But if you don't have a social security and you offer an alternative method for them to do that same background check, as in getting fingerprinted or giving more demographic information, then they should not be able to deny you based solely on the fact that you don't have a social security number. Is that correct, Joe?
Yeah, that's absolutely correct. So if they're asking for a social security number for a specific reason, and you can satisfy that reason with an ITIN number or some other form of identification, then they can't hold it against you saying no, social security only. If they're trying to say social security only, that might be cause to say, I think I'm being discriminated against, because people with social security numbers and those without are going to be different classes of people, often related to citizenship status, permanent residency status, and national origin. So asking for a social security number, that's not discrimination yet. But if they don't let you satisfy it with some other means, we might have a case of discrimination on our hands. And then real quick also to add to that, remember, you don't actually have to be from another country to be discriminated against national origin. Your parents, your grandparents might be from another country. Your ancestry could be used against you. That's still fine. So a U.S. citizen can make a claim for housing discrimination, even though they're a U.S. citizen, and they're making the claim based on national origin. That's still okay. Okay.
And there's a question in the chat. I don't know if we want to, oh, we'll answer it at the end. Okay.
Okay, yeah, well, yeah, okay, perfect. Okay, so let's talk a little bit about disability. So a disability is a physical or mental impairment which substantially limits one or more major life activities. And we'll talk a little bit about major life activities in a second, or right here. A major life activity would be caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. So any kind of disability that substantially limits those type of major life activities counts as a disability. Disability also includes a record of having such an impairment or being regarded as having such an impairment. I want to give this as an example. In the 1980s and 1990s, when the AIDS epidemic hit the United States of America, a lot of individuals who are suffering from the disease might have shown signs of like lesions or something like that. And a lot of people were denied housings thinking that they had AIDS based on certain lesions. A lot of people who didn't have AIDS, but they still had the scars or they still had the marks, were also denied housing because they thought they had AIDS. That still qualifies as disability-based discrimination. The individual didn't have AIDS, but they were regarded as having AIDS. And that qualifies as discrimination for having a disability, even though you didn't have the disability. And then the law also covers someone who is associated with a person with a disability. So if I'm looking for housing and I'm going to be the one on the lease, but my spouse has a significant disability, and I'm denied based on my spouse's disability or my child's or the person I'm caring for, that would still qualify as discrimination based on a disability. So next slide. And so let's talk about all the different ways you can be discriminated against for a disability. One is through denying somebody a reasonable accommodation. A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including its public and common use space. That was a long sentence. Basically, the idea here is that in order for somebody with a disability to enjoy housing at an equal level as somebody without that same disability, they have to be able to, a landlord must be able to accommodate that person by changing a rule or make an exception to a policy to say, this policy discriminates against you. If I get rid of the policy, then you can enjoy housing equally to those who don't have the same disability as you. For example, a reasonable accommodation would include allowing an assistance animal, even if there is a no pets policy, or creating a reserved accessible parking space for a specific resident. A reasonable accommodation, and we'll get to reasonable modification in just a sec, but a reasonable accommodation is loosening the policy to make sure that people with disabilities can enjoy the housing. And if we go to the next slide, yeah, there's a picture right there, perfect example of an individual who needs a seeing eye dog. If the apartment complex said no pets allowed, this needs to be allowed. And this would be an example of accommodating a disability by changing the policy. So the next slide, now we talk about reasonable modification. A reasonable modification is a structural change made to existing premises occupied or to be occupied by a person with a disability so that he or she can fully use and enjoy the premises. Reasonable modification, this is different from accommodation, whereas a modification means we're going to actually change something in the physical structure of the building. So this would be like adding a wheelchair ramp where there's only stairs, making sure that doorways are the proper width so that wheelchairs can get through, or lowering countertops in a tenant's apartment complex so that somebody, again, in a wheelchair can use that. And remember, it's not all wheelchair related. If your disability requires some sort of modification to the structure of the housing, and as long as it's reasonable, then the landlord has to allow for it. Now, one thing to keep in mind, if your housing is backed by federal funds, then this is going to be the responsibility of the complex, the landlord, the owner, the federal agency that's providing the housing. But if it's a private landlord-tenant relationship, oftentimes it's going to be on the tenant to afford the costs of the modification, and then also on the tenant to restore the unit back to its previous state. So it's not that the landlord has to spend extra money to accommodate the individual and modify the structure. They just have to allow the tenant to move forward with the structural modifications as long as the tenant can restore it back to its previous state. And again, a key word in all of this is reasonable. If a landlord denies somebody a request for a modification, if the landlord can justify that it was an unreasonable request, you know, now we're kind of playing the game of what's reasonable and what's unreasonable when it comes to denying somebody a housing right and so forth. Okay, so let's move on to the next slide. And yeah, perfect example, the ramps. Go ahead.
Okay, so now we're going to talk about familial status. And this is referring to families with minor children. So children under the age of 18 in the household. This is considered, you know, discrimination based on children under 18 in the household is what we talk about when we say familial status. So it includes pregnant women and persons in the process of adopting or securing custody of a child or children. This includes foster children and grandchildren as long as the person has legal custody or written permission. So when we say discrimination for familial status, one example would be if you're in an apartment complex and you're told family with children can only be in this certain area of the apartment complex. That is not allowed. You are not, it's not allowed for you to be limited to only certain areas in the complex, or, you know, being access to certain facilities in the complex because you have children.
And one thing to throw in there, so let's say you're a family, you're a single mother and you have 5 children and you're trying to rent a 1-bedroom apartment. That's not discrimination. That's the housing isn't appropriate for that size of a family. There could be state law, state ordinances that talk about the number of people who could live in a housing unit or so on and so forth. But if it's a 3-bedroom apartment and you have 5 kids or something like that, and they're trying to say, sorry, we don't rent to kids, that's discrimination. So we want to make sure that the stories we receive from individuals and the stories that people say, I think there might be discrimination, we definitely have to kind of get behind the initial reaction and make a determination that says, is this a violation of a housing ordinance or is this actually discrimination? All right, so we'll move on to the next slide. So does protected status protect you from everything? And as the example I just gave, the answer is no. So tenants and borrowers still need to abide by other housing rules and agreements. So for example, a family with children can still be evicted for not paying rent. A person from another country can still be denied a home loan due to a poor credit history. And a person with a disability may not get all of the modifications requested if certain requests are not reasonable. This is the key concept of fair housing, is that, however, a family with children cannot be evicted because they have children. A person from another country cannot be denied a home loan because she is from another country. And a person cannot be denied modifications because he has a disability. We're really looking at the why were you denied housing. And if the why is based on discrimination, that's when we have a violation of fair housing. Okay, so we'll go to the next slide. So when is a violation not a fair housing violation? So sometimes landlords or housing providers mistreat you, but it's not a violation of fair housing. So we'll go to the next slide. And I think we have a poll question for this next one. Is that right?
Yeah, so we're going to give an example and then we want you to tell us whether or not it's a fair housing violation. So a landlord does not give you 24 hours notice before he enters your unit. He is a man and you are a woman. Is this a violation of fair housing? So we'll go ahead and pull up our poll. Oh, that was the other poll, I think. Yeah.
Oh,
yeah.
No, yeah, this is right. Okay.
No. Oh, are you seeing the poll for this question?
Yeah, is this a violation of fair housing? Yeah.
Oh, okay. I'm seeing.
All right. We're 50-50. Oh, there we go, 75-25. Okay. We can end the polling. I think we just have a small group tonight for the recording. All right. So our audience tonight is saying that yes, this is, well, we have 1 vote for no. So if we go to the next slide.
Okay, so the answer is, it depends. As the answer usually is in legal questions. So this alone, what we've given you, is not a violation of fair housing without any more information. However, if the landlord engages in sexual harassment or threatens to evict you based on sexual advances, then it would be a violation of fair housing.
And I'll throw some more examples out there. So in the example we gave, we said a landlord does not give a tenant 24 hours notice before entering a unit. He's a man, or the landlord's a man, the tenant's a woman. This would be this might be a violation of Florida landlord-tenant law, but it's not a violation of fair housing. Florida landlord-tenant law says you must give, I believe it's 12 hours notice ahead of time, and the time that you enter the unit must be within reasonable hours or reasonable business hours. I believe it's 7 a.m. to 8 p.m. I think those are the hours. That's Florida landlord-tenant law. That's separate from the federal fair housing. Now, let's throw another scenario out there. Let's say in that same facts, the landlord who's a man and the tenant is a woman, he always gives 24 hours notice to all the male tenants, but he never does for the female tenants. Now we have fair housing because he's basically saying, I'll follow the rules for the men, but I won't follow the rules for the women. That's going to be fair housing discrimination against gender. And then again, like our answer says here, if it ever results in any kind of sexual harassment, we're back to fair housing. So I hope we can kind of see the difference between how what the landlord is doing is probably wrong, but when does it fall under fair housing and when does it fall under state law or county ordinance or another area of law? All right, we're going to do another quick scenario for you with another poll question. Let's do the next slide.
And don't worry, we will come back to your questions
Yes.
in the chat.
Yes. Okay, so we have another scenario to read to you. So, is this a violation? A bank refuses to give you a loan based on not having a credit score. You don't have a credit score because you just became a legal permanent resident to the U.S. Is this a violation of fair housing? All right, let's throw another poll up there. So is this a violation? Voting is in progress. We have some folks thinking. Take a few more seconds to make a guess. All right, we can close the polling. All right, so we have 67% saying no, 33% saying yes. And if we go to the next slide, we'll see that the answer is... Again, it depends. By the way, if an attorney ever asks you a hypothetical question, the answer is it depends. The poll question was unfair. If we'd have had a it depends option, everybody would have gotten it right. The reason why it depends is that this is a bank decision based on criteria that is lawful when determining if a customer qualifies for a loan. Banks need credit scores to determine if they're somebody that they want to lend to. However, if the bank had a policy that said only U.S. citizens need apply, now we might have a violation of fair housing. Or if the same bank said, sorry, the only way we'll check your credit score is through a social security number, that also might be a violation of fair housing because there might be other ways to check credit scores that aren't related to social security numbers. If the bank has other avenues to satisfy finding an applicant's credit score, then the bank needs to go down that route. They can't basically say, our solution is social security numbers, and if you have them, good for you. If you don't, we're sorry. Because that's going to impact national origin more often than it's not. So again, it depends. So what we want to look for is, how are you treating me versus your other customers? And if I'm getting treated differently, is it because of my protected status, national origin, sex, race, color, and so on? So if we go to the next slide. Okay, so are there non-fair housing violations that may still be unlawful? Yes, and we've kind of talked about a few here. So just because there's a violation does not qualify as fair housing violation, it doesn't mean you automatically lose. There's other laws, and certain discriminatory activity may fall under the Civil Rights Act, county and local ordinances, state landlord-tenant laws, or consumer protection laws. So you might be saying, I feel like I'm being discriminated against, but it might not be fair housing, but it can still be unlawful somewhere else. And we really want to make sure that a lot of viewers and audience members understand that a lot of times landlord-tenant relationships, they can kind of get really gray and really muddy, and maybe they start to be a lot of conflict between the landlord and the tenant. The landlord isn't necessarily violating your fair housing rights just because they're being mean or they're not, allowing for certain things. What we're looking for is discrimination. But if a landlord isn't following the state laws, that's a whole other area of law that they're violating, and you still have a right to a certain remedy. So any law that a landlord is violating, you're protected from. Yes, so next slide. And so what happens if you think you're the victim of fair housing violation? Well, first step is to contact us, okay? Contact myself, contact Veronica, contact Florida Legal Services, and we'll put our contact number or our information up there at the end. The reason why it's important to contact us first is because we're gonna help you determine if you have a legitimate case and which response and strategy is best for you. So we'll go through the intake and we'll basically help you understand where was the discrimination? Was the discrimination the reason for denial? Were you denied housing for some other law or something like that? Was there another law that was broken? And then once we go through that full intake, we can help you and assist you with making an official complaint to the Department of Housing and Urban Development, or HUD, or maybe your complaint is better or most appropriate for the Florida Commission on Human Relations. Maybe you live in an area such as Orlando or Jacksonville where you have a Fair Housing Assistance Program, a FAP, and we can make the complaint directly to them. Or maybe your complaint is more appropriate for a legal services organization. And then finally, you might have a complaint that's just so urgent and the remedy needs to take place now, and we don't have time to go through the channels of filing official complaints. We might need to find a private law firm that just can kind of take your case right away. Real quick, before we move on to the next slide, I just want folks to know that if you're facing an emergency situation, there's remedies available for you. Sometimes going through the lengthy complaint is not right for you, but sometimes even while facing eviction or maybe harassment is leading to some sort of violence or something like that, you can do a couple remedies at the same time. You can file restraining orders while going through a HUD investigation. Like, the law is there to protect you, and as long as your story qualifies for protection, our job is to help you find the right channel and the right strategy to make sure that you get the remedy that you deserve. So we'll go to the next slide. And okay, so that's our contact information. It looks like our logo is in front of the email. It might have just formatted. Yeah, I think when we switched formats, but it's fairhousing@floridalegal.org. You can also go to our website, floridalegal.org/fairhousing. And then my number is 407-801-4224. And once again, fairhousing@floridalegal.org is the email address. So let's open it up to questions. I know we had questions in the chat box, but I'd love to kind of hear the questions and then we can respond to them. Does that work?
Can we do the poll one more time before we just kind of wanted to see how you feel now at the end of the slides, and we wanted to bring up the same poll that we did at the very beginning. Now that you've heard our presentation, how would you measure your knowledge about your rights in respect to fair housing? So if you don't mind, please go ahead and answer the poll again, and we'll see if we did a good job at informing of your rights.
So we started, we were
3.5 was before.
3.5, so anything over 3.5. Pat ourselves on the back. All right, I know we have a small audience, so we've had three folks vote so far. That's fine. All right, we'll go ahead and we'll take it. All right, so we moved up to a 4, and I'm glad to see that, but I'm also, it's actually best that we're not at 5s because this is where the Q&A takes place. And remember, so many questions end with the answer of "it depends." So let's move forward with some of those questions and we'll see what answers we can get for you. So
you want me to go ahead and read through and then you can answer?
Okay, you want to do it that way? Yeah, that'll work.
I think we have enough time to go through those and then maybe have some additional if people still have other questions.
All right, that's a great way to do it. Yes.
Okay, so the first one I'm seeing from Jack, in the case of the example of the Christian community, I can't be denied housing if I'm atheist or don't prescribe to any religion?
Exactly, yeah. They can't use religion, lack of religion, faith, anything like that as the reason for denying. Now, if it's an official Christian community, like they have the proper documents, they've gone through the proper channels to acknowledge themselves as saying, you know, it's not that this entire neighborhood must be Christian, but maybe it's housing provided by a church specific for like, this might be overdoing the example, but like a priest, like what do they call it? The rectory, I believe, is where priests live. Like they can keep it to just priests, you know, like but that's a very specific example. But I hope you understand what I'm getting at. The idea is that if it's officially confirmed as a Christian community living, there might be some exceptions, but they can't just claim Christians only need apply, and if you're atheist, sorry, you're not allowed to rent here. Anything linked to religion is going to be a violation of fair housing. And it reminded me, remember, this includes advertising. So if you see a for rent sign or a Craigslist posting or Facebook, for rent, apartment, Christians only, that's a violation of fair housing. Your fair housing rights, you're protected from the moment a place is advertised all the way through to the end of your lease, okay? And probably past the lease as well if you're trying to renew your lease and stuff like that. So I hope that answers that question. You do not have to subscribe to any religion, and whatever you are cannot be used against you.
Okay, so then the next question was, what about renewing rent? So this is in reference to the Social Security number. What if they rented without a Social Security number, but when they went to renew, the landlord is asking for it and no renewal is given due to no Social Security number?
That is a great question, and it's a great question with a perfect "it depends" answer. But the question we want to ask right away is, if a landlord says, sorry, I need a Social Security number, and you've already rented from this landlord before, you want to ask, why do you suddenly need my Social Security number? It wasn't a problem in the past. Why do you need it? If they have a valid reason, maybe they have a valid reason that says, look, our apartment complex just bought out by another corporation, and they have policies linked to credit scores, you might find yourself in a situation where the new policy is actually linked to a valid reason. But if it's just a traditional landlord-tenant, or maybe you're renting a house or you're renting an apartment from, a couple of units or something like that, and suddenly they need a Social Security number, we're going to want to ask why. And if they don't have a valid reason for why, there's a good chance they're linking that to national origin or some sort of discrimination. And they're trying to use that Social Security number as an excuse for a valid reason to deny housing. We really got to get into the weeds of that one. And that would be, if you know of anyone with that story, that's a perfect story to refer to us so we can help that person kind of walk them through the whys and whens and all that kind of stuff to kind of pull out, is there a discrimination on hand? That's a great question.
Okay, so then there was a few questions about 24-hour notice. I think just generally, do they need to give notice? I think you maybe answered that within the presentation, that there is a 12-hour notice if they have to come in for example, a maintenance issue or something like that. But then there was another question, whether it's applied to cases where the owner lives there and has less than 4 units.
That is a great question. Okay, so the exemption for an owner-occupied house with less than 4 units, so maybe you have a very large home, you live in one of the units, and the bedrooms or the basement, I keep saying basement, Florida, a lot of basements, maybe the attic is sectioned off, so everyone kind of has their own entrances. Maybe they share the same front door entrance, but they have keys to their own individual units inside the house. And the owner occupies one of the units and the other 3 units are rented out. They're exempt under the fair housing, okay? But they're not necessarily going to be exempt from every state law or county ordinance. In relationship to giving 24-hour notice, that's going to be a state law violation. And so the state identifies you have to give 12 hours notice, and the time that you're going to enter the unit is between 7 a.m. and 8 p.m. business. If the tenant doesn't respond to the notice of entering the unit or doesn't give a better time, the landlord can give the lack of response as an excuse for still moving forward with entering the unit. One thing to keep in mind in that example of the exemption is that even if you are an owner-occupied landlord and you have less than 4 units, there are still things you cannot discriminate against. You still can't advertise whites only or English only. That's still going to be a violation of the Civil Rights Act and, fair advertising and consumers and all that kind of stuff. So we might not have a violation specific to fair housing, but you still can't do it because there's other laws that you're violating. You might be able to get away with saying, Well, I don't want to give the wrong example, especially as this recording might be viewed by larger audiences. But the owner occupied less than 4 units, it's exempt from the fair housing, but there are still going to be activity that you cannot do under other areas of civil rights and state law. But that's a great question. That's a perfect example of where state law and federal law might not be in perfect sync, but you're still protected.
And I'll just add to that real quickly. If it's a house and it's a roommate situation, that is the only instance where you can specify gender. So let's say, you know, you are a woman and you only want to have other women roommates. That is allowable within the home, within one home where you're sharing common spaces.
Okay.
So there was a question about, is it common, or what is common practice of banks to deny credit due to people without credit score? I'm not sure if we would have the answer to that.
What is common practice of banks to do? Yeah, so if a bank needs a credit score in order to make a decision to give a mortgage, that's not going to be a violation of fair housing. And this kind of gets a little tricky, especially with new rules that are being passed by HUD as we speak. And I definitely can't speak to how these new rules are going to be played out, especially if this is recorded, because there's a lot of litigation and kind of response to new rules. But if a bank is using a practice that has a disparate impact upon a certain population, that might be a violation of fair housing. There are new rules that kind of open the door for when it is and when it isn't. And right now, it's probably not responsible to go into the details of when it is and when it isn't. But specific to this question, if the bank can find other ways to validate your good credit history without a credit score, I can't say that they must, but if they're only doing it for people with citizenship and not doing it for non-citizens, like, we have to find that classification. When do you implement this rule? When do you not enforce this rule? Does this rule actually help you get to what you're trying to find out? If the only way to find out someone's credit history is through a credit score, that might be fine. But if there are other ways to determine that this person is a good risk, even without a credit score, we might want to have to dive into that. I know that's not a clear answer, but it's a great question and a great topic that really has a "it depends" answer.
So I have just a very quick example of something that maybe is, you know, a common policy or practice, but then it can be used in a discriminatory fashion. It's not related to housing, but I think it could help kind of people to see what we're referring to as far as like how are your policies applied. So there's an example of going through a grocery line and paying with a check. There's been a lot of instances, and we've heard through, you know, different trainings and just anecdotally that oftentimes white people, for example, are not necessarily asked for extra identification and, you know, extra kind of documentation to prove that you are who you say you are. And then a black person or some other person of color comes through the checkout line, and all of a sudden they're pulling out the bad checkbook and looking through and saying, let me make sure you haven't written a bad check before. So that's a policy where it's being applied in a discriminatory fashion. It's a policy that they have, but who they're choosing to, you know, really go through every checks and balances, that's when it can be a discrimination.
Yeah, that's a great example. So like if I'm at a bank applying for a loan and I'm a lawful permanent resident, I have a green card and I have a social security number and I have everything they're asking for, I just don't have a credit score because I don't have any credit cards. I've never borrowed money. I don't have, you know, a previous mortgage. I don't have a car payment. Therefore, I don't have a credit score. But the same person next to me who's a U.S. citizen has the same background as me, no credit card history, no credit score, you know, no mortgages, no debt. but they do the mortgage for them and not for me, now we have discrimination on our hands. And it's because I'm a permanent resident, they're a US citizen. There's probably a national origin-based discrimination there. If they deny both of us, then it's probably bank policy to say, sorry, we need people with credit scores. If they work with him and not me, we're looking at discrimination.
Right. So next question was, which laws supersede over others? For example, local, state, consumer law.
Okay, so federal law supersedes all other laws. The states cannot make laws that conflict with federal law. The Fair Housing Act is supreme over state laws. Now, state laws can get more narrow. They can be more protective, but they can't be allowing for more discrimination. So if Fair Housing Act says you're protected race, color, disability, religion, sex, gender, and families with children under 18. And now let's say a state wants to specifically identify sexual orientation, they can do that because they can add more protections. They can't just take away protections that the federal law already gave. In relationship to state and county ordinance, state law is going to supersede county ordinances. So it basically goes big down to little. I love the question, though, because it also recognizes consumer law. So we talk about fair housing and housing law. I love that question because we're talking about multi-jurisdictional issues. I might be denied housing because I don't have a credit score, and it might not be discrimination, but it still could be a consumer based practice that is a violation of consumer law. I'm still protected there. It's not so much that the fair housing is going to supersede consumer law, it's that they're supposed to work together. So if you're not protected here, but you are protected by this law, go ahead and get your protection. The idea is that there's enough laws out there that you're going to find your protection where it fits best. So if it's at the federal level, they don't supersede each other. But if you're talking federal to state, the federal law supersedes the state.
So, and I want to be mindful of time. I'm not sure if we're going to get to all the questions, but I think this one is pretty timely. And the question was, how do these rules apply under the CDC COVID-19 eviction freeze?
Okay, perfect. I love this question. Happy we get to answer this. So most states throughout the country had their own state moratorium or suspensions on evictions based on inability to pay rent. Florida's moratorium ended September 30th or August 1st at midnight, or October 1st at midnight. But the federal CDC guideline, the moratorium that's nationwide, is in effect. Now, in order to qualify for this, the tenant must provide a letter to the landlord with very specific language as to, I can't pay rent. I've tried every remedy through government benefits to find my rent. If you don't let me stay, I'll be homeless. And there's a list of very specific criteria that you need to put in that letter that you're going to give you to your landlord. That protects you from eviction based on inability to pay rent. But you can still be evicted for violations of other areas of the law or the lease. So if your landlord finds you engaged in criminal activity, you can still be evicted. If the landlord finds out you have people living in the unit that aren't on the lease, you can be evicted. They cannot evict you for failure to pay rent as long as you provided them with that official letter that matches the criteria. The reason why this is so important to fair housing is that if a landlord can no longer evict you based on rent or failure to pay rent, they might be looking for other reasons to evict you. Those other reasons might be discriminatory. So it's kind of like all of a sudden fair housing became extra important because if you're not able to be evicted for failure to pay rent, all of a sudden those other reasons to be discriminated based on discrimination, landlords might be looking in that, in the weeds of discrimination to find a different way to evict you. And one thing I want to make sure of is that just because they can't evict you for failure to pay rent doesn't mean you don't still owe the rent. When the moratorium is over, you still have to pay that rent. It's not that you're forgiven the rent, it's just that you can't be evicted for failure to pay it.
Okay. Let's see. Yeah, and in speaking with other fair housing advocates, we've just heard that it's just a time when renters in particular, are more vulnerable to this type of discrimination because the landlords are sort of have their hands tied in other areas. let's see, I'm sorry. What can one do if your landlord doesn't want to rent or renew your lease and threatens you with deportation?
That ding, 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 ding. That sounds like discrimination to me. That's like retaliation, basically saying, I'm not going to rent to you because you're somebody who might be able to be deported. If you connect the dots, that's a national origin discrimination. Now, if they say, I'm not going to renew your lease because you participate in criminal activity on the premises and you're an unlawful or you're an undocumented person in the United States, I don't know, that it still seems like discrimination to me. But again, it's a great question because you have to ask, why are you not renewing my lease? Is it because I have unlawful or undocumented status in the US? Or are you not going to renew my lease because I violated the lease and it just so happens that I do not have proper documented status in the US? But if they're threatening you with deportation, it sounds like those dots have been connected to one another. But this would be a perfect example of bring that referral to us so that we can go through the story and really kind of check off the whys, the whens, the whats, and everything like that to make sure that we've have that kind of the nexus or the crossroads of I was denied housing because of discrimination.
Okay, we're a little bit over time, but I don't know if we want to unshare the screen and see if there's any there are a few more questions on the list, but
if there's just a few, I don't mind zipping through a couple.
Okay. All right. So one question was, are landlords supposed to accept housing vouchers or can they deny you?
That's a good question. That has to do with additional, I believe most housing vouchers, and please other attorneys jump in, USDA and Section 8, and it's like a program. If you have a housing voucher and you just walk up to a landlord and say you have to accept this, there's more to it. It's not just a yes or no, it depends. Again, we'd have to kind of go through the history, because if you just simply own a house and you're renting it out, I can't say for sure if you absolutely must accept a voucher, but if you have accepted vouchers from other tenants, then why are they denying your voucher? That would be the question.
And also, I'll just mention that in Alachua County, there is an additional housing ordinance that has some additional protections. And if I remember correctly, they might have something around the vouchers. And in addition, there was also something about immigration status. So that's not included in the protected classes for fair housing, necessarily immigration status specifically, although many times that can be linked to country of like national origin, race. So just wanted to mention that.
Yeah. I like this question about denial based on COVID.
Oh, right. Can I deny the landlord access to the rental because I'm afraid of COVID-19?
I think the short answer is yes, with valid reason to suspect COVID-19. If you know that the landlord tested positive and is currently infectious, I believe that's going to be a safety issue that you can say, it's a bad idea for me to let you in. If you're simply assuming by being a member of the general public that they might be giving you COVID-19, I think the answer gets a little more gray. You might have to say, I'm going to let you in as long as you wear a mask, we're socially distant, maybe I'm not home at the same time you come in, you have to clean up after yourself. Remember, the landlord still owns the unit. So to simply deny them access to something they own, it has to be for a real valid reason. Usually that's going to be written in the lease, or that's going to be a part of state law, county ordinance, or something like that. Simply saying, because I'm afraid of COVID-19, it might need a little bit more. Yeah. Okay.
And then I'm not sure, maybe it says it's from Campesina Farmworkers, so maybe that's Gianna. The question says they said they received funds from the CARES Act, and I'm not sure what the question is exactly.
I wonder if it's...
It was more a response.
Oh, okay.
It was more a response because that was one of the excuses that they say for not renewing you, or say they have the rental, they didn't use a social security number, but now they are asking for a social security number. Say, why you are asking me now for a social security number as if before I didn't need it?
That's interesting. And the tenant received funding from the CARES Act?
Yes.
Well, then that tells me that that tenant has a social security number. Because in order to have gotten money from the CARES Act, you had to have had a social security number. So I wonder, I mean, that would be one of the situations where as we asked more questions and we investigated, we might learn that the landlord was trying to catch the person having money they weren't supposed to have. And so by proving they had a social security number, then they could say, okay, it's fair, you got your money legitimately. But it sounds discriminatory on its face. Like, yeah, as the details start to come out, you start to realize the landlord might be asking questions they don't need to ask.
Yeah. So the last question I'm seeing from Jacques, it says, in regards to issues to disabilities or accessibility, what about mental health?
Yes, mental health qualifies as a disability. Remember, the key word in disability-related discrimination is reasonable modification, reasonable accommodation. Modification is being lenient with your policies and rules so that you can have fair access to housing as long as it's reasonable. Mental health is, you know, it's been around for hundreds of years, but we're only recently starting to recognize it as a disability. But it does qualify under disability-based discrimination. That's a great question, and I'm glad it was asked. So yes, mental health qualifies.
And Joe, is that because it's considered something that substantially limits one or more of your major life activities?
Yeah, and yes, thank you for asking that. As long as you can say my disability limits this life, this major life activity, this is why I need it. The follow-up question is, do you have to show proof? Great question. Okay, if you're requesting an accommodation or a modification based on a disability, and the landlord says prove that you have the disability, there's a good chance you're going to have to say, yes, I do have this disability. You can't claim something you don't have. If it's reversed, though, and the landlord says, I'm saying no because I think you have this disability, you don't have to have that disability. And I hope that makes sense. Landlord discrimination, assuming you have a disability, don't have to have it. Reverse it. Requesting an accommodation based on a disability that you say you have, it's most likely that you are going to have to show some sort of proof that you do have that. But what we're looking for is that you can prove you suffer from limitations to a major life activity because of the disability. So you don't have to say, I suffer from mental health, and it has to be extreme. It has to be enough to limit your major life activities. Great question.
Okay, I think we have gone to the end of the questions, and we're just 10 minutes over, so I think that we're
good. Okay.
Great questions. Thanks for sticking with us the whole time, and thank you so much to Veronica and Joe for all that great information.
Yeah, I would say real quick, if we want to end the recording for the video, and then we can kind of say some goodbyes on the other side of that. Does that work? All right. Thank you, everyone, for watching.
Thank you.
Then